Hello everyone, in today's video we are going to discuss about different types of writs. Let's begin. So there are 5 types of writs. Those are mentioned in our Indian Constitution. These are Habeas Corpus, Mandamus, Prohibition, Certiorari, and Quo-Warranto. Only Supreme Court and High Court has an authority to issue writs under Article 32 and Article 226 respectively, so let's just quickly begin with the first and most important writ, Habeas Corpus. In Latin, it means, you shall have the body. This writ is issued by the court to release a person who is illegally detained or arrested. It's like a court telling the police or authority, bring the person here and show us why you've locked them up. Why is it important? It protects your personal liberty. No one, not even the police, can hold you without a proper legal reason. For example, a journalist is picked up by unidentified officers and held at an unknown location. His family files a habeas corpus petition. One more example, a person is illegally kept in a rehabilitation center without consent. His friend files a habeas corpus to free him. The famous case of Adam Jabalpur v. Shivkant Shukla, 1976, during the emergency, the government detained many people without trial. One of them was Shivkant Shukla. The Supreme Court, shockingly, said, even if your personal liberty is taken away, you cannot file habeas corpus during emergency. This judgment was widely criticized and later overruled. Today, we believe that even in emergency, basic must be protected. Another case law is Sunil Batra v. Delhi Administration, 1978. Sunil Batra was a prisoner kept in cruel and inhuman conditions. He filed a habeas corpus petition not to get out of jail, but to stop the jail authorities from violating his rights. The court said, even a prisoner has human rights. Habeas corpus is not just about release, but about protecting dignity. Next we have writ of mandamus, the command to act. Mandamus is used when a government official is refusing to do something they are legally required to do. A public body is sleeping on its duty. You want to ensure that public powers aren't misused or ignored. Mandamus cannot be issued against private individuals, president or governors for their constitutional duties. For example, a qualified candidate is denied appointment despite being selected through a public examination. He files a writ of mandamus to compel the government to issue his appointment letter. The famous case C.G. Govindan v. State of Kerala, 1960, studio microphone emoji. In this case, a person had the right to be promoted, but the government wasn't processing his promotion. The court issued a writ of mandamus and said, backhand index pointing right emoji, if someone has a legal right and the government has a duty, they must act. Another assay law is Manjula B.V. State of Karnataka, 2007. A qualified candidate was being denied appointment by a state body. The court said, when selection is valid and merit is proven, the government cannot delay or deny. A writ of mandamus was issued to direct the state to appoint her. In short, when public duty is being ignored, mandamus is the court's command to act. Next, we have the writ of prohibition. In Latin, prohibition means to forbid. This writ is issued by a higher court, like the Supreme Court or a high court, to a lower court or tribunal to stop them from proceeding in a case they have no power to decide. It's the court's way of saying, stop right there. You are crossing your legal limits. Prohibition is used when a lower court or tribunal is acting without jurisdiction, or exceeding its legal authority, or violating the principles of natural justice. Prohibition is issued before the final order or judgment is passed. Think of it as a legal break applied just in time to prevent an unlawful act. For example, a consumer court starts hearing a criminal defamation case, which is outside its jurisdiction. The accused files a writ of prohibition in the High Court to stop the proceedings. In famous case of East India Commercial Co. Limited v. Collector of Customs, 1962, in this case, a customs authority was about to pass an order without proper jurisdiction. The Supreme Court held, when a body acts beyond its powers, the High Court can stop it through prohibition. This ensured the tribunal didn't cross legal boundaries. Another case law S. Govinda Menon v. Union of India, 1967. Here, the High Court issued a prohibition against a tribunal that started proceedings it had no power over. The Supreme Court clarified, prohibition stops judicial or quasi-judicial bodies from continuing when they have no right to proceed. In short, if a court or tribunal is overstepping its authority, Prohibition is the shield against judicial overreach. Next we have the writ of certiorari. In Latin, certiorari means to be informed of. It is issued by a higher court to quash or cancel an order passed by a lower court, tribunal, or authority when that order was made without proper jurisdiction in violation of natural justice or is legally incorrect, unlike prohibition, which prevents a wrong from happening. Certiorari fixes it after it has already happened. Certiorari is used when a court or tribunal has already passed an illegal or void order, there is a clear error in law, fair procedure was not followed. Certiorari is like a legal eraser, it wipes out bad orders. For example, a university tribunal expels a student without giving her a chance to be heard. She files a writ of certiorari in the High Court to quash the decision. In a famous case of TC Basapa v. T. Nagapa, 1954, in this case, an election tribunal passed an order without following proper legal procedure. The Supreme Court used certiorari and said, any order passed without jurisdiction or violating natural justice can be struck down. This case established the wide powers of courts to ensure fairness. In short, when something goes wrong in judgment, certiorari is the legal remedy that sets it right. At last we have come to the fifth and final constitutional writ, Quo-Warranto. In Latin, it means by what authority. It is used to challenge a person who is holding a public office without legal authority. Imagine someone illegally sitting in a government position. With this writ, you go to the court and say, by what right are you in that seat? Show your authority. Quo-Warranto is used when a person is wrongfully occupying a public office, their appointment violates eligibility rules, there is no proper legal authority behind their selection. This writ ensures transparency and prevents misuse of power. For example, a person without the required educational qualification is appointed as the State Information Commissioner. A citizen files a writ of quo warrant, challenging his right to hold the post. In a famous case of University of Mysore v. Govindarao, 1964. In this case, a person was appointed as a university professor without meeting the qualifications. Someone filed a writ of Quo-Warranto, and the Supreme Court said, if the law lays down qualifications, no one can be appointed without fulfilling them. The court cancelled the appointment. In another case of Jamalpur Arya Samaj v. Dr. D. Ram, 1954, here, the court clarified that Quo-Warranto is available only against public offices, not private or religious institutions. So, if someone is misusing a public title, the court can step in, but not for private bodies. In short, Quo-Warranto protects the integrity of public positions. It asks, show us the warrant under which you hold power. And that wraps up our 5 dates of the Indian Constitution. So, now that all 5 writs are done, a question arises, can we file them in any court we want? Great question. But the answer is no, not just any court. There's a powerful difference between the Supreme Court and the High Courts when it comes to writs. So what's the difference? The difference between both the writs is, the Supreme Court can issue writs only for protecting fundamental rights. This power comes from Article 32 of the Constitution. It's called the Guardian of Fundamental Rights. But, the High Courts can issue writs for both fundamental rights and other legal rights. This power comes from Article 226, and it's much broader. Remember the Ramesh Thapar case? In Ramesh Thapar v. State of Madras, 1950, the Supreme Court held that Article 32 is itself a fundamental right, meaning a person can directly approach the Supreme Court if their fundamental rights are violated. The Supreme Court is the protector and guarantor of fundamental rights, and for Article 226, in case of TC Basapa v. T. Nagapa 1954. The court clarified that Article 226 empowers high courts to issue writs not just for fundamental rights. So if any one ordinary legal right is violated, they can't go to the Supreme Court? Exactly, they go to the High Court. Supreme Court is for fundamental rights only. High courts are more accessible and cover a wider range of issues. The conclusion is, 2 courts, 2 paths. 1 aim, justice. Subscribe, it's legal for more such informative videos.